The Code of Civil Procedure contains the law relating to the procedure in suits and civil procedure. Full stop. It provides the procedural formalities, which the parties to a suit require to comply with, right from the stage of institution of a suit. Full stop. The limitation for every procedural formality is provided for the code, and it starts with the institution of a suit. Full stop. Para. It would be relevant to look into the provision contained in Rule 10 and 10A of the code. Rule 10 provides for return of a plaint in all cases where a court is unable to entertain it for want of territorial or pecuniary jurisdiction to the court in which the suit should have been instituted. Full stop. Under this provision, if the court is satisfied that it has no jurisdiction to entertain the suit, it is its duty to suo motu return the plaint for its presentation before the proper court. Full stop. In such a case, there is no need even to frame a preliminary issue on the question of jurisdiction. Full stop. In other words, it is mandatory on the part of the court to return the plaint for being presented to the proper court when it comes to the conclusion, at any stage of the suit, that it has no jurisdiction over the subject matter of the suit. Full stop. Dismissal of the suit for want of jurisdiction, in such a situation, is not proper. Para. Rule 10A is comparatively new. Under this rule, wherein any suit after the defendants has appeared, the court is of the opinion that it has no jurisdiction, should return the plaint, and before doing so shall intimate its decision to the plaintiff. Full stop. The plaintiff, thereupon may make an application as contemplated by subrule bracket 2. Full stop. If the plaintiff makes such an application, the court shall fix the date of appearance by the parties in the court in which the plaintiff is to be presented, and give notice of such date to the parties. Full stop. Since the defendant by such a notice is made aware of the suit against him and the date when he has to appear, the notice can be treated as a summons within the meaning of Rule 1 of Order 5. Full stop. A date of notice to the defendant, therefore would be the date of service of summons and the time to file return statement as contemplated by Order 8, Rule 1 would the plaint in the court which has jurisdiction. Para. Reliance to the judgment relied upon by the learned counsel for the parties will have to be made at this stage. Full stop. In Amar Chand Inani versus Union of India, capital IR 1973 SC 313, the Supreme Court was dealing with the submission by the learned counsel for the appellant that the suit instituted in the trial court by the presentation of the plaint after it was returned for presentation to the proper court was a continuation of the suit filed in carnal court, must be deemed to have been filed in the trial court. Full stop. Para. The Supreme Court was dealing with an interlocutory application filed by the appellant in a disposed of appeal seeking direction to the Gurgaon court to take up the suit from the stage at which it was transferred and to decide it expeditiously. Full stop. I do not propose to give the facts in detail of this case. Full stop. In short, the defendants, after about 8 years of filing of the written statement, filed application under Order 6, Rule 17 of the Civil Procedure Code seeking an jurisdiction of the court. Full stop. The amendment was allowed and the objection as to the jurisdiction was upheld. Full stop. That order was confirmed by the High Court as well as by the Supreme Court. Full stop. The Supreme Court, however, during pendency of the appeal against that order, directed the trial court to proceed with the suit, however, it was stated that the court would not deliver judgment until further orders. Full stop. Accordingly, the suit proceeded till the stage of pronouncement of the judgment. Full stop. It is against this backdrop the application was filed by the appellant seeking direction to the Gurgaon court to take up the suit at which it was transferred and to decide it expeditiously. It appears that the court in which the suit was filed by no territorial jurisdiction, and hence the plaint was returned for its presentation to the proper court.